All right, everybody. Welcome back for our second edition of Q&A for a former USCIS officer. Working with our friends here at Boundless to share some information with you and answer some of your questions. My name is Eric Finch. Just want to remind everybody I'm not a government official. Everything you hear that we discussed today is not official government policy, and I am not a government official sharing that information, nor am I a legal professional. This is purely anecdotal based on my experience and some of the information provided by some of the people who asked questions for this event. So with that being said, let's kind of dive right in, address some of the questions. My colleague is observing the chat and will share some of the questions that come in during our chat. And hopefully we'll see what we can get around to in terms of the questions that we had submitted beforehand. So dive right in. First question I had is, why are the processing times taking so long these days? And I think this is a complicated question, but one that I can talk about in a lot of different ways. So I think we're all aware of what has been going on in the world for the last 18 to 24 months. We had a deadly pandemic that swept across the entire globe, shut down international travel, made it extremely difficult to do all kinds of in-person things like interviews and collect documents, submit documents, work with the various government agencies that are needed to get the things that you need to start the immigration process. And in addition to that, the Department of State and Department of Homeland Security, these big government offices that handle a lot of the immigration work, they have also been victims of COVID pandemic. They've had a lot of workers who were struck down, some even passed away. Offices had restricted occupancy. So there's all kinds of procedural things that have just made it very difficult for the system to operate the way it was designed to. In addition to that, you have things like staffing shortages where, in this market, a lot of people have decided to move on to other jobs or new career options. And that's made it difficult for a lot of long-term government employees to maintain the staffing levels that they need to process documents in an efficient manner. Finally, you have a lot of people who have been separated for so long at this point that they begin to run into problems with eligibility. So, for example, if you had a fiancé visa that you were looking to file, you may not have seen your fiancé in two or more years, and that makes it hard for you to qualify even to file the paperwork in the first place. So, the government has done some studies to look at this problem and figure out exactly why they're having such a hard time getting back to normal. I don't have any definitive answers for you. Another problem that has been very difficult for most people is that a lot of the overseas consulates and embassies of the United States have basically shut down operations for almost the entire pandemic. So now they have massive backlogs of tourist visa appointments, student visa appointments, immigrant visa appointments that they're trying to prioritize. But if you're just looking for a simple visa that allow you to visit the United States for the first time and go to Disneyland, for example, that's going to be quite a long wait if you're just starting the process now. And it's not really clear when they'll get back to normal. From looking at the IV backlog and the information that the National Visa Center puts out, it looks like we'll probably have somewhat normal backlogs by somewhere around 8 to 9 months from now, at which point people should go back to something resembling the wait times that they had before the pandemic. I know that's a long time for people who are waiting to get family members or other people into the United States. But there's a lot of talented people in the government who are looking at this problem and trying to figure out a way to reduce these processing times. Okay, so for the second question, I had a question that said, if I submit an application and travel to the USA to visit my boyfriend, will it cause issues? So, yes and no. All right. What you have to understand is that there's two different types of visas. There's immigrant visas and there's non-immigrant visas. Non-immigrant visas are things like tourism and student visas and temporary work visas. And those have certain rules around them that basically say, like, you must use this visa for its intended purpose. Otherwise, you will cause some kind of violation and it could cause problems for your immigration status and your permission to enter the U.S. Now, you have... it's not clear from this question exactly what the application that you're talking about is, but the common scenario that people encounter is, you meet somebody and you want to either file a fiancé visa for them or a spousal visa, say you get married overseas. And then the question becomes, this process takes so long, sometimes a year or more, like, is it really realistic that I would not want to or be able to see my fiancé or my spouse during that time while they're in the United States? And people have different reasons for needing to be separated, perhaps career reasons, or perhaps somebody needs to take care of their family in another country. So the question they have is like, well, is it okay if I use my tourist visa to go visit my spouse while I'm waiting for my immigrant visa to be ready to interview? And in that case, it sort of cuts both ways. Like on one hand, obviously, if you filed some kind of immigrant visa petition, then you have immigrant intent. And immigrant intent is the exact thing that's supposed to disqualify you for a non-immigrant visa. But in most cases, the way the government looks at it is if you're taking the time to file the paperwork and you understand the wait times and you have a valid reason to go and use that non-immigrant visa temporarily to enter the United States, well, that's something that they can consider. So it's not really a definitive answer, and it's sort of case by case. Another example that people have is like, say your mom and dad have filed some kind of like immigrant visa based on their relationship to one of their brothers and sisters. So those visas can take 10 or 15 years to become ready to grant and issue. If you want to get a student visa during that time and come and study at a U.S. university, can you do that? And the answer is usually yes. It just, you need to be cognizant of what other things that you have in the system at that moment, and make sure that when you talk to immigration officials or visa officers that you're very transparent about what's going on, what your timelines are, what your intentions are, and that the fact that you understand what the visa that you're applying for right at that moment is for and what the rules are about that visa. Okay, next question was, how does the background check look after you have a green card interview? So this is something that I can't really talk about in a lot of detail because the government considers a lot of this to be sort of privileged information. But, in a nutshell, yes, when you get to the interview step and you are applying for a green card, the government will look at your criminal record in the United States and in some cases ask for information about, places where you lived overseas and criminal record documents from there, just to make sure that you don't have anything in your personal history that would cause a problem under U.S. immigration law. And there are some other databases they look at that are more attached to things like national security, and that will be looked at, and that's something you may or may not know much about. But if they need some information from you, usually they'll reach out and ask you for things so that they can make a good judgment about whether like any negative information that they find is applicable to you or could cause a problem for you in the immigration context. So I don't think it's something that most people need to worry about. If you have had a criminal incident in your past, one way that you can prepare properly for the green card interview is just to obtain the documents like the criminal police reports and records from the court that talk about the incident and what the outcome was, so that you can be ready to show that to the visa official or USCIS officer and discuss that with them. And then based on legal guidance that they have from the immigration lawyers that work for the government, they'll make a good decision about what, if any, extra steps you need to go through to overcome that negative information. Okay, and I'll do one more, and then I'll circle back with my colleague and see if there's any questions that have come in. We'll take a little break and do a few of those. So the next question I had is, at the interview, can I correct a mistake I made on the I-485? So the I-485 is your adjustment of status form. It's one of the longer forms that the government uses for immigration green card processing. And it's pretty common. It not only does it require like several pages of personal information, but also asks you like several pages of questions. Some of them are somewhat confusing about your past and your activities and your immigration history and organizations that you've been affiliated with. And people make mistakes. I mean, certainly, the government's supposed to set this up so that individual people can file their own applications. And yet, it's comparable to filing your taxes in terms of complexity. It was quite common that we saw folks who came all the way through the process and had still errors or updates, and that's fine. At the interview, you're fully capable of discussing with the USCIS officer any changes that have made if you've moved since the last time. And that's a big part of the interview. They'll spend some time going over the form, confirming with you that you still have the same address, same phone numbers, the information about your relatives and parents is correct. And then they'll go through all the questions as well. And it's not considered a negative thing if like you answered no to something and then you talk about it during the interview and decide you want to change that to yes. The only thing that I would be cautious of is, you need to be transparent. So if the officer gets the impression that you made an error in an attempt to hide something from them or change the way that they were looking at some kind of information, then yeah, that could lead to a slight problem. And again, I don't want anyone to feel like this is a gotcha type scenario. Like, the job of the officers at both the consulates overseas and at the field offices in the U.S. is to work with you to resolve issues. Underneath it all, like, you are a person, as a potential immigrant who has some kind of a relationship with either a U.S. citizen or a U.S. employer, and they have the right to request that you receive this immigration benefit. So unless there's some problem that can't be overcome via an interview or some kind of special waiver processing or something that exists in current immigration law, the job of the U.S. government official is to help you find that solution, and they'll work with you if possible. Now, there are a few things that you can have in your past or in your history that will cause you to be refused or denied some kind of immigration benefit. And that's something that a lot of times you probably need to talk to a legal professional to understand and resolve. Okay, I'll kind of do a couple of questions that have come in during this process. Let's see what we have here. So we talked about background checks already, so I'll just talk about this briefly. There was a question: do immigrants need to get a background check once they are in the USA from the USA? This would be, somebody who came to the USA perhaps as a tourist or with a student visa and is now applying to adjust status to a green card holder. It will be done during the adjustment of status step. Like, that includes a background check that's done by the agency. And usually, aside from providing any kind of court documents or police records that you may already have, there won't be anything you need to do personally to make that happen. They'll just do that with the systems that they have internally in the agency. Second question was, if you already did a K-1 interview, do you have to do it again for the green card? Yeah, this is one where it's important to understand the difference between the Department of State and USCIS, which is the agency under Department of Homeland Security that handles immigration matters within the United States. So if you get a K-1 visa, you go to a consulate and you have an interview and you granted that visa, the K-1 is interesting because it's technically a non-immigrant visa. So they want to give you the option to enter the United States as a non-immigrant and then, meet your spouse and spend time with your, at that time, fiancé. And then if you decide not to get married, then you're able to simply leave the United States, no harm, no foul. And, you can look at other options in the future, and there's nothing negative about that. But if you do decide to get married and then go and apply for the green card, then yes, in most cases, USCIS will ask for an additional interview because, again, they don't necessarily know and have access to the full information about what was talked about or looked at during your overseas interview. Now, in some cases, they will give, especially under circumstances like today where they have a long processing time and backlog, like we talked about earlier, they do have the option to waive that interview. And in that case, you would just receive a request for certain things that may be missing from your file, at which point you may get approved without an interview for the adjustment of status after you enter on a K-1. But in that case, more often than not, they will still ask for an interview at the next step, which is your I-751 removal of conditions step that happens 2 years after you get your green card. Now, that's for people who've been married a relatively short amount of time when they adjust status. So generally USCIS will get their interview either at the adjustment of status step or at the I-751 removal of conditions step. There may be a few lucky people who don't have to do either one, but I wouldn't count on it. Okay, one more here. There's a question about translations. The question is, do all docs, supporting documents with these immigration applications have to be translated? What qualifications should the translator have? This is a tough question to answer because it varies a lot. I think for USCIS, they do expect translations. It's not a requirement, but realistically, if you want U.S.-based, government officials to review your documents, you're going to need to translate those for them. Now, generally, people will go to a licensed translator, which is different countries have different things. If you're getting documents from Mexico, for example, usually they'll have a service that has some kind of credential that they will then affix to the translation, saying I'm a certified translator, or I've taken translation training. In the U.S., I don't think it's any like sort of specific government granted authority, but you may want to have a person do it from the perspective of a company that has a guarantee and warranties versus having a person do it who may not be trained as a translator or a person translating documents and just does it based on their language knowledge. But yeah, I know for some folks where price is sensitive and they have the capability within their family to translate documents. I've seen things done by brothers or sisters or cousins or other family members where they simply sign at the bottom saying like I am fluent in both languages and this is my translation of this document. So I think generally because it's very important to have an accurate translation, it's better to go with somebody who has experience doing document translation specifically. But I don't think there's any hard and fast requirement for any specific license or credential. The government will accept pretty much whatever you provide as long as it seems to accurately represent the information on the form. There was a question here around, I think it's good to have a little discussion about the National Visa Center and what's happening right now with overseas interviews. The question is, how long is the NVC going to hold on to the paperwork before sending it to Manila? In this case, this person is applying for an interview in Manila. Is the embassy making any efforts to process things? So the short answer is yes. The embassy is working through a tremendous backlog. And, the MVC is kind of like the straw that like all this is trying to flow through before it gets out into the bigger cup of the embassies and consulates across the world. And for that reason, the MVC in a certain way is serving as a bottleneck, and they have their own backlogs that they're trying to work through. But you have to understand that the NVC really cannot pass your information to the consulate until the consulate has interviews available to schedule. Now, I'm oversimplifying a little bit, but if Manila is telling the NVC that we have no appointments, open for the next 6 months, then it doesn't make any sense to keep piling more and more appointments onto Manila. It makes more sense to hold them at the NVC where they can be managed and people have a central area that they can go back to and correspond with before the interview is actually scheduled. And it makes a certain type of sense because you're going to have a much harder time getting information and updates from Manila if your case is sitting in a huge backlog there than you will from like NVC, where you did all the document submission and they have people in a central facility where they can look at your case and give you updates. And also, what happens for a lot of people when the wait times are long is that they actually move themselves. So say you're waiting for an interview in Manila and then you decide to take a job opportunity in Tokyo. You're going to have to change your interview location. And it's difficult to do that if it's already sitting in Manila and to claw it back to the NVC and then have the NVC send it to Tokyo. What they'd rather do is just kind of try to get as close to the interview time as possible and then put it in the place where the interview will take place. So I know that's probably still a little confusing, but that's generally how the NVC process works. And right now, like I said, just because there's so much backlog and so few appointments available, it just feels like it takes a long time for it to move from the NVC to the consulate step. But, in normal times, like pre-COVID, this was quite fast. Like you would submit your documents to NVC, they would make the judgment that you were documentarily qualified, and then they would, within 3 to 4 weeks, you would receive, information from the consulate about your appointment notice. And at the point at which they get back to somewhat of normal, like that NVC to consulate interview scheduling step should get shorter and shorter. Okay, there's a bunch of these coming in. All right, I do want to cover the ones that were submitted in advance, so let me pivot back to that a little bit. This one is not technically about immigration specifically, but I'll try to answer it as best I can. There was a question, can I visit the USA from the UK unvaccinated? Are there any options at all? So many of you have probably heard that as of November 8th, the the Biden administration made an official announcement a couple days ago that they're lifting the travel restrictions, the regional travel restrictions and the country-based travel restrictions. And they're basically rolling out a policy that says that any fully vaccinated traveler with certain tests and going through a certain process can now travel to the United States, as long as they go through the proper steps. And I think the key word is vaccinated and fully vaccinated. They have said that they will accept people who have a combination of vaccines. So perhaps you got like one Pfizer shot or one Moderna shot, but whatever the normal course of treatment for that fully vaccinated status is, Usually in the U.S. or in your country, they will accept that. They've said they'll accept all the vaccines that were approved in other countries, like the Sinopharm and some of the ones that were developed in Europe. And yeah, once you meet those qualifications, you should be able to provide that information to the airlines, book a trip, and travel to the United States as you would have under normal circumstances. But the question here is, can I come as unvaccinated? And to me, and again, this is just me personally speaking based on my experience, that I think will remain quite difficult. Why? Because they're putting their sort of line in the sand here on this vaccinated status, and they have mentioned that there'll be some limited cutouts for emergency cases or things around like humanitarian things. But I would expect the bar to prove that to be quite high. Just as it is for things like humanitarian parole currently, you would have to provide quite a bit of evidence, at a high level, that this is truly an emergency. You would have to probably undertake certain precautions. You might be restricted in like what types of travel you could use, or what venues, or how you were able to, board the plane. It could be extremely expensive. So yeah, I would expect that people who are not vaccinated will have a very tough time traveling to the United States for the foreseeable future. Again, vaccinated, yes, that should be quite doable as of November 8th. Unvaccinated, I think, will be very difficult. Okay. Here we have a question. I think this is about sort of public charge and financial documents. It says, me and my wife are living in our parents' house for the past year. What documents do I need to show? All right. Well, sorry, I don't think I can really address that particular circumstance, but I think what they're trying to get at is, it's been a tough year for a lot of people. A lot of people lost their jobs last year, and we do know that in order to receive certain immigration benefits, you have to overcome what we call the public charge rule, which means the government wants at least some sense that you will not immediately become dependent on U.S. taxpayer public support if you're granted permission to come and live in the United States. Now, normally the way that you overcome that restriction is by showing that you have an income. So the U.S. sponsor would say, like, okay, well, I have this job and I make $60,000 a year, and it's just me in my house, and I want to bring over this person to be my spouse. That meets the requirement, because it's usually pegged to what we call the poverty line, which is, depends on how many people are in your house and things. But and if anybody wants more information on that, a simple Google search will give you the actual numbers. But what you do with this process is you submit documents like your tax returns and other evidence to show that you're above that number, and then the government's basically considers that problem eliminated. Now it becomes a lot harder if the people in question have no income in the prior year, because the government looks primarily at this year, but also last year, and to a lesser extent a couple years before that. So if you made $0 last year and you are saying that you're going to make $60,000 this year, it becomes a little bit more challenging for you to prove that. And you could still get there. You could get a letter of verification of employment from your current employer that says you're salaried. And you could get, some of your W-2 information, or you could get your pay stubs that show hey, I'm making this every week, and it's a 80-hour pay period job. Therefore, it over the rest of the year, I can calculate how much money I'll likely make. And again, that's sort of before taxes and things like that. So it's not it's not your take-home pay. It's the sort of top line, money that you make every year before all that stuff is taken out. So, I think that's a good way to think about it. A lot of people are getting back into the workforce this year. The government, I think, broadly speaking, does understand that this was a kind of a challenging, 1 to 2 year period for a lot of people. And again, I have no inside source on this, but I think some leeway will probably be granted. But you're going to want to do everything you can to help the government understand what your earning potential is and has been and will be. If you were making $60,000 in 2019 and you are back on the job expecting to make just as much money this year, and you can talk about that confidently and show that history and present that information in your application, then the fact that you didn't make a lot of income in 2020 might not be as big of an issue. Okay. Had a question. Does the immigration process for fiancé visa allow for not meeting for religious reasons? This would be in the context of I think in this case, the question is for Muslim religion followers in Pakistan. So this is a tough one, and this has changed over the years. Yes, there is a cutout in the law that says for like people in countries or religions or cultures that are traditionally or have the tradition of not interacting before marriage, it is allowed in that context for somebody to not meet the in-person meeting requirement for fiancé visas, and that is designed to be culturally sensitive to regions where this is still fairly commonplace. That being said, I would say due to a lot of reasons, including fraud over the years, the agencies have become much more and more restrictive about granting exceptions to these kind of things. The thinking being, there's all kinds of ways that people can interact and talk to each other now without an in-person meeting, but an in-person meeting tends to be a feature of people's like actual commitment to get married, and building a relationship in person is very different from doing so online. So if you're in a country where this is quite commonplace, you could probably like Pakistan, at least at least ask for this and say like, this is our situation. We feel that we fall under this exception. Whether it will be granted or not, that I cannot say. And also the time it takes to look at a case like that, what essentially happened is, having not met that basic requirement and asking for an exception means that the case will be more heavily scrutinized. And, you might be in a situation where then the consulate starts reaching out to people to say like, can we have some third-party verification of this relationship? Can we talk to the parents? Can we see, the scenarios where the family has done this with other children to confirm that this is actually happening in general and not just for this specific case? So, I think it'll make your case more complicated. If you're truly in a situation where culturally, like, there's just no way around it and that's just the way it has to be, then I think you're fine sort of representing it that way to the government. But if you're also in a place where this is not common and you don't have a lot to substantiate why you need to do this, it's going to be hard for you to convince the government that you don't need to meet this in-person meeting eligibility requirement. Okay, let me take a couple here. There's a question about the NVC again. Will the NVC respond sooner to a resubmitted rejected document than they did for the first application? Generally, yes. I think once the case receives like initial review, it goes into some kind of like follow-up like QA review type step, and it's assigned some sort of case manager or put in a queue that gets looked at again more quickly when you respond to requests or upload documents. So yeah, in that scenario, I can't say for sure, and it's not a guarantee in all cases, but yeah, most people that I've spoken to have indicated that once they receive the initial review, any follow-up document submissions they make tend to be looked at and reviewed faster. And we're not talking about minutes, but probably within days. Okay, and then we had a question. There was a question: who makes the decision to waive a marriage-based interview? Is it NVC or the field office? Marriage-based interview, I'm not sure that they're ever waived overseas. I guess it's possible because the consulate still wants to collect your passport, get your biometrics, print the visa, and put it in your passport, and give you all the things that you need to travel to the United States. Domestically, yeah, sometimes they are waived, and usually that is a scheduling decision. It's not usually a decision made by the actual adjudicator. What they'll do is, like, when they transfer the cases to a field office, sometimes they'll triage those and look at the cases that from their perspective are less complex, perhaps people that have like clear evidence of meeting all the qualifications, and they feel that they could approve this quite easily without having an in-person interview. Like I said, a lot of times the K1s will get their AOS interview moved because the feeling is like, well, this person just talked to a DOS officer 90 days ago. Why do we need to bring them in again to talk? We'll just catch them again at the removal of conditions step in 2 years, and that would be a more productive interview. So yeah, I think it's more of a scheduling decision, and it's made at a higher level, usually at the service centers where work allocations are made and capacity can be looked at. And okay, last one. I think we're we're almost at time, so I'll do this one really quickly. What happens once USCIS receives the paperwork? We submitted a month ago and only got a mail saying they received it. So when something gets submitted to the USCIS, usually it goes through a lockbox where they do simple things like confirm that your payment will clear and that you have like the basic paperwork that you were asked to submit and you're not missing anything major that would prevent them from looking at your case. So they'll give you a notice when they accept it, and then they'll give you another notice of action when they have actually taken the first step to review it, and you'll get another one when you have your biometrics appointment scheduled, and then usually you'll get another one when they're ready to schedule the interview. So usually you get like 3, and like the most important one. Well, I guess they're all important, but the one that is really important is the first one you get that has your receipt number. Once the items have been received by the government and processed through the lockbox, they assign a receipt number, and that will be the reference that you use to follow up and check on the case throughout the whole process. So make note of those receipt numbers. Always keep all your I-797C notice of actions, and in general, any piece of paperwork that you get from the government during the immigration process, I would make 3 copies of, and make sure that you have access to at all times, including on your phone for reference, because anytime you interact with a lawyer or with the government or with Boundless Immigration, if you're working as a customer for the Boundless company, they're going to want to know that information in order to be able to help you and understand what's happening with your case. All right, I think I just nailed it right on time. So great conversation. Love answering the questions. I hope this was useful for everybody. And I'll be working with my colleague here at Boundless to set this up and do this again. If you guys find this useful, please circle back with us on Instagram and all our other social media accounts. Tell us how you felt about it. Share with your friends so we can get more participation. The mission here at Boundless is to spread the knowledge and help people understand this difficult system and do what we can to make this process more manageable and stress-free for all of our friends overseas and our friends in the United States. So thank you very much for coming out and listening to me talk, and hope to talk to you again soon.